This program is brought to you by Emory University.
Our first afternoon session. My name is Polly Price. I'm a faculty member here at Emory Law School. The title of this panel presentation is Should Religious Groups Oppose the Children's Convention? These are lurking questions which we have that have been at least beneath the surface and sometimes on the surface throughout this conference. And now we have an opportunity to direct our attention specifically to the views and roles of religious groups with respect to the Children's Rights Convention for the next hour and a half. The presentations we are about to hear from our three distinguished speakers include the question, should the convention be ratified and why? Overcoming religious objections to the Children's Rights Convention, and the influence of religious groups in the Children's Rights Convention ratification debates. These promise to raise provocative and timely topics. We will have time at the end of the program for your questions to our speakers. I will introduce each speaker to you immediately before his presentation. We begin first with Professor Don Browning. Dr. Browning is the Alexander Campbell Professor of Ethics and the Social Sciences Emeritus at the University of Chicago Divinity School. He is a world-class scholar of practical theology and ethics. Since 1991, Professor Browning has led the Religion, Culture, and Family Project at the University of Chicago. That project has yielded a number of new books, scholarly articles, scores of public forums and conferences. The most recent work, Marriage, Just a Piece of Paper, was produced as a book and also as a documentary film shown on public television across the United States in early 2002. Dr. Browning has focused much of his research on the relation of religious thought, particularly theological ethics, to the social sciences. Dr. Browning is not a stranger to this law school. He has been here in residence at times in the past with the Center for the Study of Law and Religion. Would you please join me in welcoming Dr. Browning?
Thank you very much for the lovely introduction. I should alert you that in addition to these presentations, most of us were asked to write papers as background to our remarks. For law journals and things like that, they generate long papers, so I'm giving you a 20-minute version of the 40-page paper. And I say it's 20 minutes, actually it's 19 minutes and 34 and a half seconds. I use my Martin Marty timing watch. Martin Marty will speak to you later on, a good friend of mine, one of the most punctual people in the world, and so I should be able to get through this in a relatively short time. I alert you because he's going to wrap this entire conference up at the conclusion, and it'll be illuminating as well as entertaining, I'm sure. I will argue that the United States should ratify the UN Convention for the Rights of the Child. But I also believe that the reasons advanced for its failure to do so should be taken seriously. In the end, it is my judgment that they do not really hold. Nonetheless, I confess that my judgment is based on an interpretation of the convention in light of the meaning of the statements about family and children in the earlier 1948 Universal Declaration of Human Rights and other UN covenants that the Universal Declaration has influenced. Insofar as the direction of many UN statements on human rights may be drifting away from the rationales of the Universal Declaration, then the grounds for refusing to ratify the convention become reasons to pause and reflect. Upon further examination of the convention, it is my judgment that the original meaning of the statements about children and family made in the Universal Declaration still, for the most part, hold in the convention. For this reason, the convention is safe to adopt for the United States. Furthermore, as I think other people have pointed out as well, once adopted and properly interpreted, the U.S. could play a significant role in shaping the proper understanding and implementation of the Convention, both at home and other parts of the world. I also will contend that interpreting the Convention in light of the Universal Declaration gives scholars interested in the relation of law and religion a special opportunity to clarify the grounds of human rights discourse and claims. Are human rights based upon positive law, natural rights, or some religious or quasi-religious narrative about the meaning and purpose of life and the dignity of human beings? Or must human rights claims for both children and adults be based on some subtle combination of these various grounds? I will hold that properly grounding the rights of children and adults requires a mixed argument, a double language that artfully yet logically brings together both natural law and natural rights with religious and quasi-religious narrative. We have already seen how various American religious and legal groups object to the Convention because it appears to give international law undue power over parents, local communities, and the constitutional rights of the 50 states to establish family law. We have seen how the Convention is perceived to give children undue and excessive freedom of expression, Article 13, freedom of conscience, thought, and religion, Article 14, possibly too much freedom to choose their friends, Article 15, some believe too much freedom of privacy, Article 16, and some believe too much freedom to testify in courts, possibly even against their parents, Article 12. Religious groups in particular have felt that the Convention might inhibit parents from raising children according to their own values and disciplines. Homeschooling advocates have been particularly vehement in the opposition to the Convention. Such groups have helped shape the long delay in its ratification by the Senate of the United States. Those supporting ratification of the Convention point to the Senate's reluctance to use the Supremacy Clause to implement human rights treaties at the level of the 50 states, not self-executing, we are told. They also point to the relatively frail report and consultation powers of the UN Committee on the Rights of Children, the only implementation instrument provided by the Convention. They point to the many times in the Convention where the rights of parents and legal guardians are asserted and preserved, and there are many times. Articles 3, 5, 7, and 9 all seem to point toward the priority of parental rights. Nonetheless, the Convention does somewhat restrict the sphere of parental responsibility, thus raising the question of its possible drift away from the balance of parental and states' rights that was achieved, I believe, so successfully in the Universal Declaration of Human Rights. For example, and there are many of these, in the Convention's famous Article 5, we find the assertion that states parties shall respect the responsibilities and rights and duties of parents. But then it concludes by defining this as the parental right, and I'm quoting, to provide appropriate direction and guidance in the exercise by the child of the rights recognized in the present Convention. Now notice, the values, morality, sensibilities that parents are given the right to help their children to acquire seem limited to those emphasized in the Convention. But what if parents believe that there is more to life, its meaning, morality, and virtues than can be found in the Convention? Do parents have the right to guide and direct their children in these values? Do their parental rights exist only insofar as they reinforce the principles and values granted in the Convention. Answering this question requires an act of interpretation. I have the point of view that what the Convention is and becomes depends upon who interprets it and how it's interpreted. It can go one way, it can go another. It is my view that when the Convention is interpreted within the wider history of human rights statements since the 1948 Universal Declaration of Human Rights, individuals, legislatures, and courts would have every right to understand the Convention as providing for the priority of parental rights and limiting law and government to the role of supporting parents and legal guardians, correcting excesses of abuse by parents and caregivers, and protecting and supporting children when there are familial failures due to death, accident, and poverty. The UN Declaration firmly establishes the priority of parental rights and responsibilities when it states in Article 16, paragraph 3, the family is the natural and fundamental group unit of society and is entitled to protection by society and the state. This statement became almost a mantra in subsequent human rights statements. It is found in Article 10 of the International Covenant on Economic, Social, and Cultural Rights, Article 23, paragraph 1 of the International Covenant on Civil and Political Rights. But what does this affirmation really mean? And what is its broader historical context? Historical research demonstrates that the Universal Declaration was significantly influenced by the tradition of Christian human rights thinking that emerged out of the Roman Catholic canon law, the thought of Thomas Aquinas, and mediated into the contemporary world by 19th and 20th century Roman Catholic social teachings. Just to let you know, I'm a liberal Protestant, so this is not an in-house argument. Historians tell us that under the influence of the first chair, Eleanor Roosevelt, an air of American practicality dominated the Commission on Human Rights. Charles Malik, the highly influential and articulate Lebanese philosopher and statesman, resisted these expediencies. He was the source of the statement's emphasis on the family as the natural and fundamental group unit of society. This phrase carries more philosophical and religious meaning than it might appear at first glance. Malik's formulation asserted that it was the role of society and the state to protect the family, but also argued that neither society nor the state created the family and endowed it with its basic rights. In using the language that he did, Malik was drawing on his knowledge of natural law and natural rights tradition that can be traced to Aristotle's views on the centrality of kin altruism. Aristotle provided much of the naturalistic and philosophical language for the centrality of kin altruism in the family theory of Western philosophy, law, and religion. His insights were used to reinforce folk observations about natural parental affections that can be found in a variety of contexts and certainly within the religious narratives of Christianity, Judaism, and Islam. Aristotle's arguments also influenced the powerful theory of subsidiarity that constitutes the philosophical core of Roman Catholic social teachings on the relation of family and the state. This great tradition was a source for Charles Malik's view of the family as the natural and fundamental group unit of society. The great Roman Catholic theologian Thomas Aquinas stated the role of kin altruism in family formation and marriage with a double language that was simultaneously religious and biophilosophical. His biophilosophical views were influenced and informed by Aristotle, and the specifically religious language principally came from Genesis and New Testament commentary on Genesis. Hence, Aquinas' complete argument about family and the grounds and priority of parental care does not stay at the level of God's commandments and scriptural interpretation, although these are indeed central and very reinforcing. He also taught the family was an office of nature and could be understood by reason and experience, as well as tradition and revelation. This is doubtless what Malik and the Universal Declaration meant when they referred to the family as a natural and fundamental group unit that is entitled to protection by both society and state. The phrase group unit invokes this rich tradition that refers to the web of natural inclinations towards solidarity, continuity, and deep attachment that spring from bonded conjugal relations between husband and wife and parental investments and care for their offspring. In taking this stand, a position amplified by the subsidiarity theory later developed by Pius XI and Casticanubian Quadragesimo Anno and the tradition of Roman Catholic social teachings, this set the stage for a critique and to some extent a limitation on the two contemporary and competing grand solutions to the world domestic crisis: the family dominated by the state and the family dominated by the market. These were the sources that informed Malik's thinking. I conclude my remarks by saying more about why human rights thinking requires a dialectical argument entailing both a reconstructed natural law theory and some narrative framework that tells us about the meaning and purposes of life. Brian Tierney, in his monumental The Idea of Natural Right, demonstrates how the tradition of subjective rights, i.e. the right to pursue and satisfy our various human needs and desires, began to take shape in early Roman Catholic canon law. But I argue that a theory of subjective rights all by itself leads to confusion. Why is this so? It is because theories of subjective rights provide no way to mediate between conflicting subjective rights, and no way to rank and organize rights into some kind of working whole. Nature itself provides no definitive way of organizing subjective rights into patterns of objective rights. This is true even when subjective natural rights are buttressed by contemporary evolutionary theory, as political theorist Larry Arnhart and many other theorists would have us do. His attempt to do this is an effort to ground more scientifically the philosophical biology found in Aristotle and used to inform the natural rights thinking of many medieval canonists, as we have seen. I believe that a narrative about the meaning and purpose of life is required to stabilize subjective rights and organize them into mediating patterns of objective rights that can order both rights and obligations and resolve, rather than aggravate, conflict. Only some narrative understanding of the human life cycle as a whole, its meaning and purpose, can give us an organized view of our needs and our children's needs in light of some theory of life's trajectory. On the other hand, without some dialectical reference to the structure and interrelationship of our natural human needs and inclinations, faculties, and powers, human rights based on confessionally rendered religious stories, although crucial and sometimes very helpful, will be equally insufficient. The recently deceased French philosopher Paul Ricoeur's theory of critical hermeneutics helps us understand the role of narrative in aiding us to select and prioritize and order our conflicting subjective needs and rights. In the longer paper prepared for this conference, I developed Ricoeur's thought at length. But the theory and philosophy of Thomas Aquinas illustrates what Ricoeur had in mind. Like contemporary evolutionary theory, Aquinas believed that the many years of human infant dependency gave human children profound needs to be cared for by their parents and cared for a very long time, much longer than almost all the other infants of the animal species. In addition, like Aristotle before him and evolutionary psychology today, Aquinas believed that parents have themselves needs to invest and care for their infants. These two sets of needs work synergistically to create the attachments and bonding that enables the human infants to grow and to flourish. In terms of medieval rights theory, these respective infant and parental needs are subjective needs when seen separately, which together, however, constitute the objective right for parents and children to have the opportunity to attach. The right to attach. You ever heard much talk about the right to attach? The right to attach is the objective right that is synergistically created by the subjective infant's neediness and the subjective parental inclinations to care. Since all human infants have two biological parents, this objective right to attachment gives rise to the right and the responsibility to marry, and the centrality of marriage in Western religious thought, and indeed in almost all human thought, religious or philosophical, of the past, is great. In my reading of Aquinas, it is the Christian narrative that tells us that all children from the beginning of creation were made in the image of God, and thus are of ultimate, pivotal, and maybe of decisive worth. This ontological claim about the ultimate status of children justifies making the subjective needs of the child the active agent, organizing subjective parental tendencies to care and tendencies to do a lot of other things as well, and thus the objective right to attach and form families. This is the tradition that was mediated by Catholic social teachings to Malik, the Universal Declaration of Human Rights, and which still lingers a little more faintly in the background of the Convention. It is in light of this tradition that the Convention should be interpreted and implemented. The point is, it has to be interpreted and properly interpreted before it can be successfully implemented. Hence, I think we should learn two things. The inclinations of nature can be used to support theories of subjective and objective natural rights, but only when viewed from the perspective of how normative cultural and religious traditions have, on the basis of centuries of experience, selected which of our natural tendencies to emphasize and to honor, and which to be handled with benign neglect. It is our narrative tradition and the narrative tradition of other cultures that select finally what is central. On the whole, the Jewish and Christian narrative traditions have selected the needs of the child as central to the formation of human rights in general and the respective roles of parents and the state in the caring for children and the child as it grows into maturity. In this sense, the needs of the child and the ontological worth of the child are what tell us that it is the first responsibility for care to rest with the parents, those most inclined, generally speaking, to care. The needs of the child are what tell us, as Malik wanted but failed to get, that this parental care should be stabilized within institutions. And first of all, the institution and the right to marry. And it is the needs of the child which tell us that the state and its laws must be ready to stand by, support, assist, protect, but never replace or disrupt the priority of the family. Although I have illustrated this understanding of the relation of narrative and natural rights on the basis of Judaism and Christianity, religious traditions that did, in fact, have definitive impact on the human rights tradition, I wager that other religious traditions, when once again rightly interpreted, can be discovered to be resources as well. But that's a task for the future and for another endeavor. Thank you.
Thank you, Dr. Browning. Our next speaker is Professor David Smolin, who is a professor of law and director of the Center for Biotechnology, Law and Ethics at Cumberland School of Law, Samford University. He is an expert in bioethics and biotechnology issues, in reproductive constitutional issues, international children's issues, including adoption, children's rights, child labor, child trafficking, family, and juvenile law and law and religion. He has testified before legislative committees in the U.S. Congress and 5 states on related constitutional issues. The title of his presentation is Overcoming Religious Objections to the Children's Rights Convention.
I'm very honored to be here and to hear all of the other speakers. I've just learned so much the last day and a half. And I'm afraid my role may be, to some degree, to play the bad guy here. I'm really not that bad. But what I want to do is to represent with some strength those who oppose the convention. To some degree, I'm not representing my own position. The title of the talk is Overcoming Religious Objections. And so the point of my talk is, what is it going to take to overcome those? Of course, I'm not going to talk about changing people's religious views. I think to say that we're going to change the views of tens of millions of evangelical Protestants so they won't be evangelical Protestants anymore is not the path to ratification. So the real question is, taking those objections with some seriousness, what would it take? I do also teach international human rights law, so I will be talking with some, will be talking about what kind of RUDs, reservations, understandings, declarations that the U.S. could adopt in the ratification process that might meet the substantive objections. Essentially, there are 3 sets of objections. One of them has been very well represented here by Professor Browning, and that is the problem of parental rights. Okay, and I'm going to talk about that in a few moments. The problem of parental rights also bleeds into what was talked about the last session, which is the problem of group rights, which is still part of the first one, but we could call independently a second one as well. This leads into a third or second, depending on how you count it, objection. That is, we've got parental rights, group rights, and then that is the apparent anti-democratic features of the CRC if wrongly interpreted. So let me talk about these substantively. As I've reviewed the objections to the CRC as put forward by various organizations such as the Family Research Council and the Homeschool Legal Defense Organization, parental rights, I think, is preeminent. When they look at the convention, first of all, they object to Article 5, which was already read by Professor Browning, in that it seems to reduce parental rights not only, as he stated, to directing children in the exercise of their rights, but even in the exercise of their rights, seems to view rights almost in a decisional way, that the parents guide the child's decisional autonomy over time. And this, from the point of view of many in the evangelical Protestant community, is a very impoverished view of the role of the parent. The parent is not simply guiding the child's decisional capacity as though he or she were a guidance counselor at a local high school or something of that nature. It goes much, much deeper than that. And I think that goes to something that's deeply philosophical about the nature of children's rights, which you enter into at the beginning when you talk about parents' rights versus children's rights, and that is the impoverished or complex notion of rights. Now, actually, I think that the Children's Rights Convention has a very complex and rich view of rights, as has been represented by many. It includes participation rights, it includes protection rights, it includes provision rights. But to the degree that it includes participation rights and that those participation rights include autonomy rights, the whole question of viewing children and their rights through the lens of autonomy is terribly troubling from the point of view of the religious communities that I'm trying to speak for. They view children primarily, and human beings primarily, through the lens of human dignity and human good. And the furtherance of rights is secondary to human dignity and to human good. And human beings are not defined from these points of view principally by their capacities to make decisions or choices. And that is viewed often to be true about adults, although certainly that's an important part of adult capacity, but very much so about children in particular. From various points of view, children do not lack human dignity if they cannot decide something, whether it's an infant or a 5-year-old. And so this seems to be an impoverished view not only of parents, but of the nature of rights. This concern then, of course, goes into the later articles, which, as we heard yesterday, were advocated strongly by the United States. Part of these participation rights, rights of religious freedom, assembly, association, rights perhaps lifted out of other places, other human rights conventions dealing with adult, civil, and political rights. And I understand the reassurances that these rights of assembly, privacy, association, and religion were originally put in there perhaps to make a political point against the Soviet Union, and therefore were about the fact that children and adults and all human beings should have civil and political rights. You may recall at an earlier stage, we were caught between two worlds during the Cold War. The U.S., as President Carter suggested in his own speech, and even under his presidency, advocating only really for civil and political rights, and the Soviet Union advocating for the economic, social rights. And so this was a point that we were going to make. The question that becomes concrete, however, is do these rights apply against parents or only against the state? Do Articles 12 through 16 apply and limit parents in their role of guiding children and raising children and having their care and custody? Do children have rights against their parents as to associating, as to media, as to religion, or only rights against the state? And that is a concern. I think that this concern, which I could also bleeds over into the interpretation of Article 19, which has been interpreted consistently by the committee to ban spanking. This is the ban on any mental or physical violence against children. In the United States jurisprudence, of course, we do prohibit under state law child abuse. We have the battered child syndrome. We do concern ourselves with child abuse, but there is a parental privilege for reasonable discipline, including physical discipline, within U.S. jurisprudence. Surveys indicate the vast majority of United States parents actually spank their children. The experts say it's a bad thing. American Academy of Pediatricians says it's a bad thing. But the question is, are we going to take away this parental privilege, limited though it may be, by adopting the convention? And that is a concern not only for those who believe that they are religiously obligated to spank, which would be some, but in general it would flow from this idea of what's the relationship between the state and the parents, and between the international community and the parents, and between the committee and the parents. In general, I would say that these concerns with parental rights bleed very quickly into notions and concerns with the right of the religious community to continue from generation to generation. Basically, this is not made as explicit in the materials, but I'm going to make it explicit. What I'm going to quote from next is a book by a legal scholar, Professor Jim Dwyer, the book Religious Schools versus Children's Rights. And this embodies the kind of hostility that the religious communities in the United States, particularly the theologically conservative ones, sometimes feel. Professor Dwyer first characterizes religious fundamentalism and evangelicalism in ways that I think are highly inaccurate, but you can read my article on that. I don't have time to go into detail. He comments on the fundamentalist movement of the 1920s, the withdrawal of the religious fundamentalists from American political life, the reentry in the 1980s. Of course, he doesn't note, but I've often viewed President Carter as the born-again president as a major part of that reentry. And evangelicals are not all Republicans, nor are they all white. But in any event, in this stereotype that Dwyer is dealing with, I think that they are. And then he says this, the backlash against, well, he says this, the reappearance on the political landscape in the 1980s generated fear and hostility on the part of mainstream Americans, liberal and conservative. The backlash against them, this is the great them, okay, the fundamentalists, them. The backlash against them triggered complaints by fundamentalists and even some mainstream scholars that they were being denied their place in our democracy, silenced in the public sphere. Some see this as a matter of fairness to persons with religious outlooks, but I see it as a problem for the education of their children. Knowing that these children will incur the scorn of mainstream America if they grow up to be like their parents, why do we not act to prevent that for their sake, rather than expect mainstream Americans to develop a respect for people who argue dogmatically for reactionary policies based upon religious premises we do not share? So when the religious community hears quotes suggesting that, as Professor Dwyer does throughout his book, we need to regulate religious education in the interest of the child, we feel that often the motivation, which is made explicit by Professor Dwyer, has to do with the desire to, frankly, take children out of the religious community and give them a kind of upbringing and education that will, so that they will not be like their parents, in the words of Professor Dwyer. I think the reaction would be the same to Professor Feynman's proposal that we look at Wisconsin v. Yoder again. It was in this morning's session, I believe, that Professor Feynman proposed that all children have to go to public school. This is something that the U.S. Supreme Court dealt with going back to the 1920s, and in the Meyer and the Pierce cases held that there was a constitutional right to educate children in private and religious schools. Fortunately, the convention permits that, but in any event, that's part of this group continuity, or this fear of what I often call in my work cultural genocide. I know this may seem bizarre to some of you when supposedly evangelicals have such political power, but it's a function of the evangelical community that they still function as a small minority and often in an immature way politically, which I'll grant at the outset. This becomes a problem in Article 29 of the Convention. Article 29 does speak positively of private education and of parental rights in that light, but it has a limitation that has been cited by objectors, and indeed has been cited by me in the past as well, in all honesty. It says basically no part of the present article, which is Article 29, shall be construed so as to interfere, this is Part 2 of Article 29, with the liberty of individuals and bodies to establish and direct educational institutions, subject always to the observance of the principles set forth in paragraph 1 of the present article. Now that idea, okay, we're not going to interfere with private education except insofar as it adheres to Article 1. Article 1 is, in the main, an idealistic statement that education shall try to fulfill the talents and mental and physical abilities of children, as we heard well spoken of by Professor Jenkins in the last session. However, it also requires that children be taught, in essence, respect for the United Nations, and also has some statements about toleration. Well, like a lot of things, this is a matter of interpretation. What do we mean by respect for the United Nations, and what do we mean by respect and toleration for all people? Of course, personally, I respect the United Nations, and I am not really speaking of that part of it so much. But in the book we've seen much quoted before, the book so well amply put out and edited by Cynthia Price Cohen and Howard Davidson, in the chapter by Susan Batensky, if I've got the name right, yes, she addressed this specifically. And she basically suggested, perhaps in line somewhat with Professor Feynman's argument, that there was a problem here, that under current law it was constitutionally protected to run church schools that were against the United Nations. We do have a tradition of some fundamentalists being completely hostile. I'm not among them, but, you know, do they have the right to run their own schools? And she suggests that this right under the convention would be taken away. She further quotes from a study about the Bethany Baptist Academy, which teaches, quote, "This is not a place where there are alternative worldviews. We put ourselves in a position of being the first and only among the religions of the world," a quotation from page 182 of this study, and suggests that religious education of that kind would be illegal, even in private religious schools, if the CRC was ratified, and that U.S. Supreme Court cases that would hold to the contrary would have to be somehow set aside. Again, the religious community reacts to statements like this with some alarm and quotes them repeatedly. Now, when we go to the anti-democratic parts of all this, I think that the objection here is really the notion of transforming American society through treaty. And I think that aside from all of that has been said, some of which I would agree with, you know, some of the criticisms that have been made of Americans and Americans being overbearing or arrogant in their role in the world, and I would agree with a lot of those criticisms. Nonetheless, I think that it is a fair concern that in the United States we are in the midst of, as has been said, some degree of a culture war. And in that culture war, it has been a strategy to go through the least democratic branch, the courts, and to secure victory there, rather than to go through the more democratic branches. And many of the issues in the culture war are precisely about the family and children, and there are constitutional decisions on such, some of which are viewed positively by the people I'm speaking about, some negatively, but there are important decisions from there, despite the absence of any text whatsoever in the Constitution directly naming children, family, parents, or whatever. And, of course, that's why we are so conflicted when it comes to nominating and confirming U.S. Supreme Court justices. And the concern is that the court does legitimately play, the federal courts do play legitimately an anti-majoritarian role in our society, but that anti-majoritarian, somewhat anti-democratic role should be limited. That is, its capacity to set policy and to set aside the views of the people as expressed through the states and through the Congress. That should be limited to the court's authority to interpret the Constitution. You shouldn't give them a whole other text. That there's something anti-democratic, and that would be made even worse by recognizing the committee, as expert as they may be, the Committee on the Rights of the Child, the 10 members, as an authoritative interpretation. I talked to Cynthia about this briefly, and again, I don't mean this ill at all. I'm sure I think I know what she meant by it, but her statement, again in the ABA study on page 33, that every document needs an authoritative interpreter, and, quote, in the case of the Convention on the Rights of the Child, that authoritative source will be the Committee on the Rights of the Child. That statement has been quoted with some fear. It's bad enough dealing with Supreme Court justices and their policy or religious or moral views in that committee of 9 without investing questions of the relationship of parents and children and men and women and so forth to a committee of 10 who may be democratically elected in some international sense, but certainly not in the representative sense established in our Constitution, and certainly come from the outside. This does not mean, of course, that the committee should not be listened to with respect, but it's the matter of being an authoritative interpreter. And I think that generally much of what we've heard today and yesterday would undergird those concerns. The idea that by adopting a treaty we are going to fundamentally change our approaches to a variety of issues that have been discussed: education, welfare, poverty, and so forth, and that it would be a good thing if somehow the courts were more active in doing that, has a certain bypassing of the American political process almost in view. And that's something that the religious communities to a large degree object to. Now, how could this be dealt with positively? What kind of reservations would deal with it? Well, they are available and they are very standard, and this is why I think that the religious communities' objections can be met. And not only can they be met, let me add a more positive note here. The American evangelical communities are generally extremely positively oriented around the issue of human rights at this point in time and around the issue of children's rights. They particularly have been active in the areas of religious liberty, the Sudan, Darfur, child trafficking, and as well very active in the area of humanitarian aid. The international humanitarian organizations like World Vision are well supported in the community, and World Vision indeed supports the CRC. So to the degree that you put your focus on these parts of the CRC, there's broad support. Indeed, the CRC is being ratified with no political objection anywhere in the United States, piece by piece. And what I mean by that is that we've had a series of ratifications over the past 6 years. The Worst Forms of Child Labor Convention, 1999, the Intercountry Adoption Act, 2000, is part of the ratification process towards ratifying the Hague Convention on Intercountry Adoption, which we're still inactive in. The 2 protocols, as was mentioned yesterday, to the Convention on the Rights of the Child, the one on sale of children and children in armed conflict, ratified, I believe, by unanimous vote in 2002, and then in 2005, the UN Convention Against Transnational Organized Crime, and for our purposes, particularly the Protocol to Prevent, Suppression, and Punish Trafficking in Persons. By my rough estimate, the United States has, without any real political objection, certainly not from the religious community, created or ratified more specific treaties implementing Articles 11, 20, 21, 32, 33, 34, 35, 36, and 39 and 38 of the Convention. And in fact, therefore, to a large degree, the kind of speech that President Carter made yesterday, of course, with his roots again in the evangelical community, granted not the religious right, but yet that evangelical community broadly shares those concerns. And so the question is, how do you let the evangelical community be the good guy that they want to be in the world, and help them help the United States to be the good guy that we all want it to be in the world? Well, in order to do so, you've got to give up using the CRC as a backhanded way to win all the little issues you wanted to win along the way in the progressive left struggle, but couldn't win by direct means. And that means, to some degree, allowing the standard ratifications that the U.S. has used in other human rights treaties. When the U.S. ratified the Convention on Civil and Political Rights, we had the federalism one that was suggested last session was not appropriate, but the federalism one, which also President Carter listed as a concern, the U.S. attachment to localism. There is, of course, the non-self-executing one, which has been a standard part of U.S. approaches. All of these are essentially, and I have a longer list, and I don't know how am I doing time-wise here. If I have time, 2 minutes to go through the whole list. So I'll leave the entire list to my paper. Most of them are the standard ones that we've had. But what I want to say about them is that, in essence, I think that this process can aid the CRC. From my point of view, as I've studied the CRC, it is ambiguous, as was pointed out last session, on critical issues. It does not have a fully worked out vision of child, family, and state. And I think that the CRC is a rousing and idealistic call to aid children, and because you cannot aid children without aiding their parents, their interests are often indistinguishable, to aid humanity for that matter. In order to make it such, however, it needs to be heard not primarily as a legalistic document to be caught up in courts and in the culture wars and to be directly implemented by the courts, but it needs to be heard by the broader society as a part of a dialogue. Now, that dialogue should, as was suggested before in the last session, lead to change, but not simply progressive change, although that may indeed be part of it, but certainly to change. But it is change in which there needs to be no single authoritative interpreter. From that point of view, I think it's important that the committee be listened to with respect, but that it not be viewed as a supreme court of the rights of the child, that it be viewed as an expert and as an aid. And if the convention can be rightly understood in this idealistic, aspirational way, and there can be protections that will not be used as a club in the culture wars, then there is indeed hope that the evangelical community, which I think wants to do the right thing, could come around. Part of them are already there, of course, but I'm talking about that great middle. It's been an honor. Thank you very much.
Thank you very much, Professor Smolin. Our final speaker needs no introduction because he has already been an integral part of our proceedings. But in the event you were not able to attend yesterday, I would like to introduce briefly Jeremy Gunn. He is the director of the Freedom of Religion and Belief program at the American Civil Liberties Union in New York City. He is also a senior fellow with the Center for the Study of Law and Religion. After being awarded a PhD in Religion and Society from Harvard University, Dr. Gunn practiced law at the firm Covington and Burling before becoming a senior fellow at the United States Institute for Peace, and later the director of research for the U.S. Commission on International Religious Freedom. He has been a visiting professor at several universities and published numerous works on American and French legal and religious history and religious liberty themes. We welcome back Dr. Jeremy Gunn.
Thank you. We're getting near the end. We have one more performance after mine, and then we can all relax a little bit. It's still a pleasure for me to be here, and it's been particularly a pleasure for me to hear the last two presentations. I wish that I had heard them yesterday and that I could have revised what I would say in light of them, but I don't have that luxury. But I thought they were very good, very profound. And I want to, in many ways, agree certainly with the general themes, but also to take a very different approach. In other words, I didn't know exactly what I thought until I heard what they had to say. Then I realized what I thought about this issue. So it's very helpful for me in clarifying this. Now, we have heard during the last couple of days that or last day and a half, that some of the issues that we are dealing with here relate to the culture wars in the United States, or that there's a religious dimension, a religious opposition. And I'd like to address some of those themes. But first, I should probably state that the words that I'm going to be saying now do not purport to be the position of the American Civil Liberties Union, so I need to set that aside so there isn't any misunderstanding about that particular issue. I think that Don Browning and David Smolin talked in a way about some of the principled arguments and objections that can be raised in terms of the Children's Convention and what those mean, how we understand them, how we explain them, how we analyze them. And I think that that's quite helpful. But I would like to talk about the issue in a very different way, that what I think is really behind the opposition to the convention is less the reasons that David talked about, though I think he has a good point, and I'm certainly not dismissing it, and those are valuable points, but I think that doesn't go to the core of the opposition. I think the core of the opposition in the religious communities in the United States, to the extent that it is there, comes less from the arguments that we have heard discussed, though those certainly are used, and more it comes from a question of identity or a sense of personality or values that are under assault in a very general way. And that's what I'd like to do is first try to illustrate this by giving you a complete hypothetical. And so we can perhaps take a look at this from a different perspective. So here's the hypothetical that I'd like to give to you. And the first part of the hypothetical will start out as being true. And then we'll go to some fancy. Let's suppose that the Convention on the Rights of the Child had been negotiated during the Reagan and Bush administrations, which it was. And let's suppose that the sort of arguments and developments and themes that Cynthia Price Cohen talked about was basically what the history of the drafting process was. So let's take that and say that we'll just take that as part of the factual case. But now we'll switch, and I'm going to change here. The General Assembly doesn't vote on it, but after the drafting process is complete, a press conference is held by several countries. And the countries that hold the press conference are the People's Republic of China, the Sudan, North Korea, Cuba, Vietnam, and Laos. They're going to hold a press conference, and they are going to announce that they are opposed to the Convention on the Rights of the Child. They will vote against it, and if it is adopted, they will not ratify it. And they offer some reasons. And the person whom they choose to be the spokesman for their reasons is President Clinton. And I'm not going to say which sex this President Clinton is. So President Clinton announces the reasons that these countries are opposing ratification of the Convention on the Rights of the Child. They say, first of all, it is too family-friendly and is not sufficiently supportive of states' rights. So President Clinton, in his analysis, notes that there are 19 positive references to parental rights, parental authorities, parental responsibilities, and there is virtually no equivalent provision that says that the states have these rights. States are given the responsibility to ensure the parental rights, and these countries object to that. Then they object to the preface of the Children's Convention. I'm going to read the language which these countries, read by President Clinton, are objecting to. Convinced that the family, as the fundamental group of society and the natural environment for the growth and well-being of all its members, and particularly children, should be afforded the necessary protection and assistance so that it can fully assume its responsibilities within the community. That's a right of the parents. It's a right of the family. Recognizing the child for the full and harmonious development of his or her personality should grow up in a family environment in an atmosphere of happiness, love, and understanding. Those countries find that language offensive. Next, the Convention on the Rights of the Child concedes too much power to presidents. There are, in fact, 36 different references to the powers of the powers of the parents that exist in the Convention on the Rights of the Child, and the countries are offended by that. There's some specific articles that these countries find to be offensive. One of them is Article 34, which reads, "States parties undertake to protect the child from all forms of sexual exploitation and sexual abuse." Unconscionable. For these purposes, states parties shall in particular take all appropriate national, bilateral, and multilateral measures to prevent the inducement or coercion of a child to engage in any unlawful sexual activity. These countries say the state shouldn't be preventing that. States undertake to prevent the exploitative use of children in prostitution or other unlawful sexual practices, et cetera, et cetera. The countries say no, they don't want to follow through on that. The countries also were opposed to Article 14. Article 14 reads, states parties shall respect the right of the child to freedom of thought, conscience, and religion. The objecting states say children should not have that right, and they are particularly offended by the second clause of Article 14, which says that state parties shall respect the rights and duties of parents, and when applicable, legal guardians to provide the direction of the child in the exercise of his or her right in a manner consisting with the evolving capacities of the child. So that one is objectionable as well. The final objectionable one which David read, I will read as Article 5. And imagine this is coming out of the mouth of Sudan or the mouth of President Clinton. States parties shall respect the responsibilities, rights, and duties of parents. Remember, David said this is the one that conservatives were objecting to. Repeating, states parties shall respect the responsibilities, rights, and duties of parents, or where applicable, other members of the extended family or community, to provide in a manner consistent with the evolving capacities of the child, appropriate direction and guidance in the exercise by the child of the rights recognized in the present convention. So that is, the states are respecting the responsibilities of the parents to do this. So these states say that they find all of this objectionable and they are not going to ratify it, they're not going to vote for it. Now, continuing this hypothetical case, the organization called Focus on the Family immediately conducts a press conference to respond to what President Clinton has said, supporting these statements by the state. And the statement of the Focus on the Family is as follows. The United Nations rejection of the Convention for the Rights of the Child proves just how anti-family the UN is. Although the UN encourages rights for feminists, homosexuals, and all kinds of minorities, as soon as they have the chance to adopt a convention for children, they reject it. The UN is anti-child, anti-family, anti-parent, and anti-American. This is the last straw. The U.S. should withdraw from the UN and tell the United Nations is willing to defend the rights of the child and the rights of the family as incorporated in the Convention on the Rights of the Child. So imagine that particular scenario. Let me go now to some of the language that is in fact used by those who are involved in this culture war to describe what is going on here and how they approach this. Again, with the question that will be underlying this is, are we talking about the precise objections which can be raised to the convention, or are we talking about identity? So, starting out with, I'm taking a few sources from a few different places from opposition to the convention. So one is Christopher Klicka, who wrote an article. He's from the Homeschool Legal Defense Association, and his article is entitled "The UN Convention on the Rights of the Child," which he subtitles as "The Most Dangerous Attack on Parents' Rights in the History of the United States." First sentence. On February 14th, 1995, the Clinton administration, already scary, through Hillary Clinton, even more scary, declared war on parents' rights in America. On that day, Hillary Clinton announced the United States would sign the UN Convention on the Rights of the Child. We have raised the specter of Clinton. In the article, we do not talk about the specter of Presidents Reagan and Bush, under whom the convention was negotiated and ratified. A second one coming from the Family Research Council. Many of the anti-family, anti-life positions we are fighting against were developed in a series of international meetings that, now we asked the question, that the Bush and Reagan administrations negotiated, no, that is not included, but that the Clinton administration was very much involved in, and very much supportive of. We have once again the specter of Clinton. This is something that is being proposed by President Clinton and First Lady Clinton. Let's take another example. The US, this one is from Patrick Fagan at the Heritage Foundation, talking about the origin of the treaty. The U.S. role in the treaty. Where does it start? Where would you expect it would start? President Bill Clinton signed the CRC on February 23, 1995, but the United States Senate has not ratified it. In not one of these documents that I've read, and there may be others, so I'm not saying that this is universal. There's no discussion of the role of other presidents in this. It is President Clinton to which it is attached. Now I ask then, rhetorically, is this an identity issue? Is this a political issue? Or is this going to the merits of the case? Well, let's look at some of the other kinds of argument that are raised in these objections. I'm going to read through some of them rather quickly, but to give you the idea of how the issue is being framed. I will suggest to you that the language that we have going on here in terms of objecting to the convention is the language of war. We are at war to defend our families, to defend our children, and we need to fight that. We need to fight that war. So, first one, back to the Heritage Foundation. Think of the language of war and how the issues are being presented. Few Americans are aware that agencies within the United Nations system are involved in a campaign to undermine the foundations of society. The two-parent married family, religions that espouse the primary importance of marriage and traditional sexual morality, and the legal and social structures that protect these institutions. It's a war against the family. Going on, the Convention for the Rights of the Child is pushing policy changes that would ultimately deconstruct the two-parent married family and counter traditional religious norms. Going on in the Heritage Foundation. To most readers, the very idea that the UN might be involved in efforts to denigrate motherhood and the married family sounds far-fetched, but they are in fact being put forward by UN committee reports. The Convention on the Rights of the Child shows, quote, a great disdain for motherhood. It wants to denigrate the role of the stay-at-home mother. The UN Convention also on the Rights of the Child is not just concerned about the elevated status given stay-at-home mothers. It's not just concerned about that. It seeks to deconstruct the status given the family by telling states to normalize out of wedlock birth. So we see the outrageous things that this convention is doing as presented in these arguments. And there are many other examples that I could give, but time prevents going further with that. Now, what I think we have happening here is clearly the presentation of a war and of a culture war where the Convention on the Rights of the Child is at war or is at struggle with the values that we as Americans cherish, that we wish to protect. I think that there is what I will call sort of a three-part structure to the argument that is based here, and I see it somewhat differently from David, but I'm not sure even whether it is necessarily in conflict. But the three aspects that are the themes that I see being repeated throughout the arguments, in addition to the argument that we are at war, is, again, three elements. One of them, there is a concern about gender issues. Gender plays through this repeatedly. And again, if I had more time, I could give you better examples. But there are, in these documents, sex-specific roles for females. Females as a mother, as a wife, and girls as future mothers. Specifically condemned in these articles opposing the Convention on the Rights of the Child are women as lovers and women out of the home. Not mentioned at all for the role of women, and role is, I think, already a pejorative term, so I apologize for that. But what is not mentioned as women as friends of other women, women as friends of other men other than their husbands, women as scholars, politicians, heroines, lawyers, doctors, etc. Women are not mentioned in any of those roles in any of the defenses of the opposition to the Convention on the Rights of the Child. So women have a particular role. There's one here that is so choice I can't. This is one where I'm going to ask you to guess what comes after. Okay, so it is saying partly some people would say that we are anti-woman. Well, that's just not true at all. We believe that women have rights. So I'm going to read something to you now. We believe, this is from the Natural Family, a manifesto, which very clearly is not written specifically about the Convention on the Rights of the Child, but it comes from people associated with the group Focus on the Family. So this is not, let me reiterate, about the Convention on the Rights of the Child, but it is consistent with the other language. Okay, it says, we believe wholeheartedly in women's rights. Okay? Above all, we believe in the rights that recognize. Now, what would you guess would follow from that? This is how they are going to argue that they are for women's rights. Above all, we believe in rights that recognize women's unique gifts of pregnancy, birthing, and breastfeeding. That is how we recognize, we show that we are not opposed to women's rights. This manifesto has been signed by hundreds of people in parts of the community that, again, are opposed to the adoption of the Convention on the Rights of the Child. So we have the issue of women and playing a gender role, and there is deep concern that somehow the Convention on the Rights of the Child is going to undermine that, whether it's the Gang of 10 that interprets the Convention on the Rights of the Child or the United Nations that is going to do it in general. There is a deep concern about that. The second theme that I see consistently within the various texts in opposition to the Convention on the Rights of the Child is the danger of sexual transgressions. And they play in a few different ways. One of them is sex outside of marriage. One of them is homosexuality. Another one, I was even surprised to see this one, was androgyny. One of the articles says that the UN is engaged in a campaign to promote androgyny, and that's one I had not heard of before. And the other one, much more serious, is abortion. So these are the issues that particularly undermine or underlie the opposition to the Convention on the Rights of the Child, that somehow the Convention is seen as promoting these or encouraging these. The final of the three themes that I see unifying the language that is being used here is undermining the traditional family. And maybe that's the pervasive one, but we go there to the roles of parents are particularly important, and the children should be cherished and disciplined, and it should be for the parents to be able to discipline them. Now, I'm arguing that those are the themes that are uniting the opposition to the Convention on the Rights of the Child for what is called the religious right, or those who oppose it in that part of the religious community. Now, I think partly what I suggested in my introductory hypothetical example is that this debate could have been framed in a very different way. It could have come out as, this is a convention supported by the Reagan and Bush administrations. It supports family. Look at all the references and look at who the opponents to this are. We need to be able to ensure it. If the United Nations doesn't do it, then it shows the United Nations is anti-child and anti-family. That rhetoric could have been used as well. That was completely possible, a completely possible scenario. Of course, that is not the scenario that happened. But instead, they chose something else. Now, what I'd like to suggest here, and this is, again, partly different from David, who raised the specific objections they have and how you can respond to those, and that's very good, and I largely agree with that. But I think we're talking about something ultimately that is more fundamental from that. Now, my point in raising these points, these themes, is not to say, therefore they are wrong, and therefore they can be dismissed, or therefore they are silly, but something is hitting them in a very personal way. When they read the convention, they do not read the portions that I'm reading, and they didn't interpret it the way that I did, or the way that others might interpret that. They interpreted it in a way of suspicion for this institution, or this suspicion for this document. We've heard Paul Ricoeur being cited earlier today. If we think of Paul Ricoeur's hermeneutics of suspicion, when we make the critical reading of the text, we have the critical reading of the text, by those who are opposed to the Convention on the Rights of the Child. We do not have the generous reading that might counterbalance where we might attempt to say what is between the two. But we have a reading of it that is based upon a feared loss of identity, and that's the issue that we ultimately, I think, will need to address if we're going to be able to solve this dilemma of lack of U.S. ratification. Thank you very much.
Thank you, Dr. Gunn. We have time for questions from the audience, questions, comments directed to any of the panelists. We have microphones that will circulate throughout, and I would ask that you would identify yourself and identify the speaker to whom you're directing a question. There's a hand in the middle.
Yeah, Johan van der Vyver. I don't want to repeat what I said earlier today, but let me just premise by reminding you that I believe that as long as the juvenile criminal justice system of the United States is what it is, that is an insurmountable obstacle for the United Nations to ratify the ICC Convention. But I seem to be the only one in the room that thinks along those lines. So let me then side with the majority and just ask a little bit to think about what the consequences of ratification will be. I did not have the opportunity of reading my paper on enforcement, but the main mechanism of enforcement is a reporting procedure, which leads to a diplomatic discourse on what the committee might regard as aspects of the American legal system or the practices in the United States which they find at variance with the international commitment. This is done on a highly diplomatic level, and the focus is not to force, not to compel, but to encourage compliance. And that would be one of the great values of ratification, remembering my own reservations about ratification, but assuming that they do not exist. That will simply mean that the United States will expose itself to dialogue regarding children's rights within the United States. There's no body in the world that can force you to do anything. The only mandatory action that can be taken is by the Security Council under Chapter 7 of its powers. If what you do to children constitutes a threat to the peace, a breach of the peace, or an act of aggression, which in any case can be vetoed by the United States. So even if there are concerns about interpretation by a committee, which you might perceive as undemocratic, the committee cannot force you to accept its interpretation. They can only engage you in dialogue and try to encourage you to see it their way. If they don't succeed, then they don't succeed. But the dialogue will then continue. So insofar as the impression might have been left in the minds of some people that once you've ratified, you will be forced to conform, I just thought it's worth just saying, and for your comments, that that is not the case in international law.
Thank you for your comments, and I agree with you that the process of the U.S. opening itself up to that dialogue would be helpful to the United States, and I think that the U.S. could play a helpful role in the world community as an advocate for children's rights more forcefully if it did join the CRC. The concern, however, is particularly the notion of U.S. courts, and that U.S. courts, which are an anti-majoritarian, sometimes rightfully so, institution, and which are caught up in the culture wars, and whom, without the benefit of texts about family, wade into these cultural matters. Given a whole set of texts about the family, what would they do with that set of texts? And it often is encouraged in the human rights community, as we've heard these last 2 days, that courts ought to take these things up. And so that's why I think that the necessary answer to that, which some might agree with and some might not, is the standard U.S. Reservation that this is, or declaration that this is non-self-executing. which some people see as making it meaningless and object to, but I don't see it that way at all. I see ratification then speaking to the legislative branch, to the executive, to the states, to society, to teachers, to parents, in an interactive way. But so long as we can keep it from being a document that is authoritative in U.S. courts, I would agree with you.
Dr. Gunn, you also wish to speak?
Yeah, just a brief point in furtherance of what Johan just said. In the documents that I've been referring to, there is a stated fear that this will become enforceable law in the United States and they will have no ability to fight against it. It is extreme. If you know, the United States has ratified many conventions, and it is difficult to get a court to even cite an international convention, let alone enforce it, and let alone enforce it against the will of the community. So it is a fear that has no basis in American history or law, but it is used as a reason that the United States must oppose ratification. So again, for me, this is sort of an identity of fear of this other thing out there, rather than a sober analysis of how one section or another can be interpreted.
Professor Browning?
Well, I just want to add, we all are on mailing lists, and I'm on mailing lists for most of those organizations you're talking about. In addition, because we live in a pluralistic society, I sometimes sit down in meetings where they show up. The conservatives tend to love the Universal Declaration of Human Rights. They, for the most part, as we've had demonstrated here, do not interpret the convention that way. Although, as you heard me say, I think they have every justification for doing it. It's what's happened in the meantime. It's their general suspicion of what's happened to the UN in the meantime, their general suspicion of the courts, their general suspicions of the judges, and their fear that almost any instrument that comes in from another place will be used in ways which are counterproductive. But they're not against all these treaties. Some of them they love.
Another question? Yes, down here at the front on my right. If you could bring the microphone down, please.
In light of what has been said, is it worthwhile to have a dialogue with some of these folks?
Is it worthwhile to have a dialogue?
Yeah.
I anticipated that question, so I came prepared with an answer, okay? We live in a democratic, pluralistic society. By various estimates, evangelicals, not just white evangelicals, but evangelicals, brown, black, white, constitute 1/4, maybe as much as 1/3 of the American population. They are not all opposed to this. Of course, most of them would fall into the never heard of it category. But nonetheless, the notion, it depends on what you mean by these folks. If you mean that there are particular leaders who may not budge, yeah, that may be the case, although I believe in dialogue myself and trying. But if you mean, again, that you're going to get this ratified in our political context, and just act as though the evangelical community is not a legitimate participant in the American democracy, I think that would be unnecessary. I think that, let me make this broad statement, since almost 90% of people here, I would guess, to the degree they are American and voted in the last election, voted on the Democratic side, not just for president, but across the board. That would be my guess. In other words, it's not a fully representative group in that way of what actually happened. But my sense, and many others, has been that to the degree that the Democratic Party ignores, denigrates the evangelical communities, they will become a permanent minority party. You have got, and that's why President Carter and President Clinton were elected, because whatever their policies, they understood and understand the evangelical communities, the ways of talking, and the sets of concerns, even if they don't always meet them in their policies. And so this almost automatic recoiling from evangelicals is not healthy. I think, as nor is the evangelicals recoiling from discussion with others to the degree that exists, which it does, healthy either.
Dr. Browning?
Oh, yes, just one more thing. At this moment in history, there are a large number of evangelicals that are very articulate, and also they have some political power. But we have to face that there are many forces in our society that are conservatizing forces, moving people and sentiment toward much of the thinking, especially around family issues, that is represented by the evangelicals. They're articulating things. And this was first brought home to me one time when I had a consultation and bringing together Hindus, Islamic people, and various other faiths with evangelicals. And on family issues, all of those people, all of that heterogeneity, all that religious diversity were more alike than separate. And we've already heard things that are happening in other countries. The more immigration, the more pluralism. There's sociological evidence that immigration will have a conservatizing effect on the society. And we have a lot of that going on. Attack the evangelicals, fail to enter into an open and respectful dialogue, and you're going to offend a lot more people than just evangelicals.
Other questions? There's a hand in the back. Oh, I'm sorry. Dr. Gunn has a comment as well.
I would like to answer this, I would say in just one word. If I chose one word, is it worth engaging the discussion? The answer to me is absolutely unequivocally yes. We should engage in the discussion, and they should engage in the discussion too. And the discussion should be about values, and the discussion should be about merits, and the discussion should be about what the meaning of the convention is and what is good about it and what is bad about it. But there should be a discussion. Last week I was in Chicago for a meeting with several different groups that are involved in church-state issues in the country on litigation on all sides of the issues. And I think that the conclusion that almost every one of us made at the end of this was there is a lot more in common with each other than we think, and if we speak about the issues in a sober way and we cease the language of cultural warfare and we start talking about what is good for children or what is good in public schools or what are the values of private schools, that the differences, they do not disappear, but you can have sound discussion and you can reach lots of agreement.
Okay, we had a question in the back.
Well, it's not a question, it's a clarification. Can you hear me all right?
Yes.
Okay. Because several people have referred to the book that Howard and I did on the Convention on the Rights of the Child and my chapter on how you interpret the convention. That was written, I want to point out, in 1990. The committee didn't start even looking at state party reports until 1992. I was extremely naive. What I did was quote simply good old-fashioned American jurisprudence of the law doesn't have a meaning until somebody has said what it means. What did I know? I didn't know what the committee was doing. We now have 18 members of the committee, I want to add. And not only that, I've discovered from having watched how processes work, it's the governments themselves that are interpreting the convention. And then the committee is giving a dialogue and some suggestions. And there's every government that I've spoken to that participated in this said it was a very constructive dialogue, and they've in no way felt in any way coerced by the committee. So I just wanted to clear that up, and maybe I should write a new article and straighten out the mess. Thank you.
I think you should write a new article, and because I think that would be helpful to getting it ratified so that role of the committee could be clarified.
We have time for another question.
This is to Professor Smolin and the panel. I was just wondering that if there isn't a subtextual motivation for the kind of almost visceral opposition or suspicion to ratification, could it be that given the American legal system's founding on common law that there could be sort of a hangover of the conception of children as property, and as in subsequent jurisprudence, property rights trumps most other rights. Could you just speak to that, like a hypothetical, if you will?
Thank you for your question. No. This is not about owning children as though they were property. I think that we have grave difficulties in our autonomy-based society when we thin out our religious traditions and reduce it to just rights talk and a very secular, enlightenment, individualist approach. We have difficulty expressing the connections we have. We have difficulty expressing the human life cycle, which Professor Browning so nicely talked about, where we have a right to attachment. I love that formulation. And of course, there's a whole psychology of attachment theory. And so it is typical in the, and I understand where the question's coming from, and I know that it's an honest and a sincere question, but the religious communities have, to the extent they're able to keep connected to the hundreds and the thousands of years of shared living, ways of expressing being connected to people, and being connected across generations, and being connected to their children, and being connected, by the way, to their husbands and to their wives. When I go home to my religious community, just to comment on the gender comment, I'm not principally a law professor. They don't care about that. They care about me principally as a husband and a father, and to the degree that I do that badly, I'm in big trouble no matter what I do here. And it's not just the women who are evaluated that way. And so there is a real, it's not just you're either property or you're autonomous. We do own one another, but it doesn't mean we're property.
Dr. Gunn?
I'd like to just say one last short thing, which will, I hope, be a little bit of humor to end what we're doing. I wanted to work this into my talk, but it really wasn't relevant, so I will say it now. It's equally irrelevant, but it may be something on which we can conclude. The Assistant Secretary of Health and Human Services, who was the Assistant Secretary for Children and Families, gave a speech to the United Nations where he spoke about what the values are that the United States is promoting with respect to children. There's a speech on December 6, 2004. And this is one where I'm going to read just the first sentence, and then you can try and guess what it is that he's going to say. So he says, what then are the principles that guide family policy in America? And he says, first, we believe that government ought to create the conditions that allow strong and healthy families to thrive. Consistent with the UN Declaration that everyone has a right to a standard of living for the health and well-being of himself and his family, we believe that government ought to, and what would you think? This is the number one thing that he chooses, at least in terms of priority. What is it the United States wants to do to create the conditions that allow for a strong and healthy family? What is it that he says? Now, imagine what you think it would be. If you could put that in the one thing that you would identify first, what would it be? He says, we believe that government ought to keep the tax burden on families as low as possible. So that's another issue that we are dealing with.
Thank you. We've come to the end of our time for this panel. It is not the end of the day by any stretch of the imagination. Before we break, let me just remind you what's coming up. After this break at 3:30, we'll have the closing keynote address by Professor Martin Marty. It will be concluding reflections on the entire conference, certainly important to this endeavor, and an apt way to conclude the event. If you did not get in your questions for either this panel or one of the earlier ones, there will be two prime opportunities to consult with them informally. One may be during this break, if you can catch them. Also, the reception that will follow Dr. Marty's remarks this afternoon would be another time to have some informal conversation. But we thank our panelists, and please join me in expressing our thanks to them, their remarks.
The preceding program is copyrighted by Emory University.